All rise.
My Lords, I've had a chance to review. I'm only going to ask your Lordships for 15 more minutes, if I may.
15?
15.
Right.
1 5. Not more than 15, I promise.
Certainly not more.
My Lords, in relation to the 1981 Act, there's no dispute on the definition of tenant that it includes a tenant at sufferance. The argument I wish to raise is based upon the deed of conveyance, which is set out in the record at page 4. Could I invite you, your Lordships, to look at that now, please? Record, page 4. Page 4. My Lord, it's a very short point based on the second paragraph from the top of the page, deed of conveyance dated 7th January 1981, registered in 1986. The classic definition...
Where is it?
Sorry, top of page 4 of the record, my Lord.
Yes.
Second paragraph from the top, deed of conveyance dated 7th January 1981.
Yes. Mm-hmm.
Yes. My Lords, in this case, one of the focuses during the trial was when the notices to quit were served and when demands for the property were made. The classic definition, and this is the point, of a tenant at sufferance is a person who holds over without the assent or dissent of the landlord. That is the classic definition. In this case, my Lord, we submit that Bim Ramdass, after the 7th of January 1981 and on the passage of the 1981 Act on the 1st of June 1981, was a tenant at sufferance. We accept, as the evidence demonstrated, that the notices to quit and found by the judge were served in 1977 and at a later date. But this is where the tenant at sufferance point comes into play. Between the 7th of January 1981 and the 1st of June 1981, the respondent, who was now the landlord or landlady, made no demand for the property. She served no notice to quit. She wrote no letter expressing either an assent or dissent for Bim Ramdass to move from the land. If that is correct, and in my submission on the evidence it is, then between the 7th of January 1981 and the 1st of June 1981, Bim Ramdass would have come squarely within the definition of a tenant at sufferance. That, in my submission, is unanswerable. But I know...
So I'm not sure what I'm looking at exactly. What are we exactly looking at?
My Lord, the deed of conveyance, which is set out in the part that I've referred your Lordship to, shows that the respondent became the landlord on the 7th of January 1981. Does your Lordship have it?
I see a reference to something. You're just referring to the deed of conveyance?
Yes, deed of conveyance dated 7th January 1981,
yes.
Registered as number 4512 of 1986.
Yes. We don't have that there.
I have copies of it, my Lord.
Okay.
And these were provided kindly by the respondent. Could I ask your Lordships to have that now?
This was the conveyance from the mother to the present respondent.
That's correct.
To the daughter.
Of the land.
Yes.
Of the land. While Bim Ramdass was a tenant of it.
Well, he was...
On my case, as my own friend says. It's the very first page, very first paragraph of the deed, my Lord, which sets out the date of conveyance, 7th January 1981.
So we're looking at this on the assumption, what assumption?
On the basis that when the respondent became landlord, she made no demand for the property from the 7th of January 1981, when she became landlord, to the passage of the 81 Act.
But we're also assuming that her mother had given notice to quit.
Yes, I accept that, my Lord, and it's a very short submission that when the change of landlord occurred, during the period between the 7th of January and the 1st of June 1981, the landlord entitled to possession was then the respondent and expressed neither assent nor dissent to Bim Ramdass remaining on the property. The tenant
in what sense was he a tenant?
Well, this is where I'm attempting to be creative, my lord. He was at that time said to be a statutory tenant. That is what the High Court found. Hill and Redmond, which the Court of Appeal in Edwin Alexander considered that the definition of tenant at sufferance does not include someone who is there with statutory right. Now, it appears again in the current edition of Hill and Redmond, and I've put that in my bundle of authorities. But here's the interesting thing. Hill and Redmond has put that in the definition without any authority. Every other publication, including Woodfall and McGarry, simply says that a tenant at sufferance is someone who holds over without the assent or dissent of the landlord. Not that they are there without or with a statutory right. Now, on the classic definition, which I submit is the correct one, whether you have a statutory right or not doesn't matter, because you are there without the assent or dissent of the landlord. Your tenancy may expire and the landlord doesn't renew it, but he may express no view one way or the other as to whether you should be there or not. My lord, I can take you to...
I'm sorry, but
Sorry.
surely the whole idea of tenant at sufferance is that it lies in the mouth of the landlord either to express consent or opposition.
Yes.
But he fails to do so. That's not a facility available to him. It's a statutory tenant, is it?
Well, my lord, if the landlord expresses no view one way or the other, it doesn't prevent a statutory tenancy from arising. If my lord is making that observation, I agree. But a tenant at sufferance is a concept at common law. And at common law, he would be a tenant at sufferance if no demand or opposition has been made for him remaining on the property. It's a short point, but it's one that I offer your lordships to try and bring the father of the appellant within the definition of tenant at sufferance. As far as the definition offered by Hill and Redmond is concerned, there is no authority to say that a person who is there with statutory right is excluded from the definition of statutory tenant. Your lordships can bear with me for just one moment. Could I invite your lordships to look very quickly, please, at tab 39 in the appellant's bundle of authorities. And it's page A1-24, part B, varieties of tenancies at the bottom left-hand corner. And it states quite clearly there that a tenant at sufferance is a person without any statutory right to retain in possession. I have tried to find out the source of that, but it doesn't appear to have come from any case. It is simply something that appears in Hill and Redmond. Can I take your lordships now very quickly, please, to tab 40, and it's page 632. And this is the extract from Woodfall. And the entry at 6.075 on page 6/32. .075, a tenant on sufferance is one who, having entered under a lawful demise or title, wrongfully continues in possession after it has ended without the assent or dissent of the person next entitled. The person next entitled here was the respondent, and on the evidence, no assent or dissent was expressed. Demand for the property occurred in 1995 when the appellant had become the tenant. And my lords, I'll simply give your lordships the reference. This is repeated by McGarry on page 262, which is at tab 34, and again does not make any mention of a statutory right preventing someone becoming a tenant at sufferance. My Lords, my Lord Walker challenged me and made certain observations about the reference to Hansard. It troubled me, and so I would like to answer it in this way. The reason I've invited your Lordship's attention to Hansard is because if statutory tenants are excluded, it creates an anomaly or an absurdity. And on that basis, I submit it's proper to look at it. My Lords, in finishing the submission on the 1981 Act, if your Lordships are against the appellant that the 1981 Act applies to him, then it necessarily means that the common law is going to have to develop, as it did before the advent of the Rent Acts, to protect tenants like this appellant and like his father. The common law did so up until the initial passage of the 1915 legislation. That continued until 1981 in Trinidad, we submit, with the passage of the Land Tenant Security of Tenure Act. In 2002, the Rent Act expired, and so the only basis upon which they can look for relief is the 1981 Act. If your Lordships are not with me, then the common law will have to develop again, as it stopped developing in the early 1920s, to protect appellants like this. And I would simply ask that if your Lordships are to dismiss this appeal, that nothing be said that landlords can use this decision to prevent a tenant from raising any other further submission to cause the common law to develop to protect him.
What would be your answer to the point that this Act should be construed fairly strictly because it has effect even though inconsistent with the Constitution?
My Lord, it comes back to why it was passed with that special majority. What is not in dispute is that it was intended to override and interfere with landlords' rights. They are the people who are not going to benefit by this legislation. In construing it strictly, bearing in mind it was passed to interfere with landlords' property rights, it may have the opposite effect as intended by Parliament in giving the landlord a get-out clause, allowing him to benefit in circumstances where the reason it was passed with a special majority was to prevent him from so benefiting. That's the short answer. My Lord, the point has been raised about pleadings, whether the 1981 Act should have been pleaded. It wasn't in this case, I accept that, and it was raised in submissions before the High Court. Since the High Court dealt with the submission, then it is a matter that your Lordships can deal with, and I don't think I need to say any more about that. Grateful. My Lord, the final point, mean profits. I simply adopt what is set out in my printed case. The order that was made by the High Court was that mean profits be paid by this appellant from 1978 onward. The law is well established in this regard that an appellant cannot be made to pay rent which is directly referable to mean profit after the death of his predecessor. And so that your Lordships have the authority, it is Tickner and Clifton at tab 24, and I'll simply give your Lordships the page reference. Page 210 in tab 24. A decision of Mr. Justice Swift, 10 lines from the bottom, explaining that the statutory tenant is not responsible for what went on before she became a statutory tenant of the premises.
Should be that, Mr. Bahaw-Nanan.
That, I believe, is that. Could I just take instructions on one matter, my lord? I'm sure that's it. Thank you, my lord. That is everything.
Thank you.
I'm grateful. I'm sorry if I went over.
No,
a little.
thank you very much. That's fine. Mr. Rowe.
My Lord, in the light of the indications which my learned friend has given and that your Lordships have given, I won't deal with the point about limitation or with the matters that I raised in my rather last-minute supplementary case. What I propose in those circumstances to do is to start with the central point about the Land Tenants Act and its proper construction, and then move on to deal with the other points in our case. My Lord, so far as the Land Tenants Act is concerned, in my submission, this is really a very simple point of statutory construction. And it's perhaps worth observing that...
Are you referring to the Rent Restriction Act, or which act are you referring to?
I was going to start with the Land Tenants Act itself, my Lord. If your Lordship prefers, I can go in the same order as my friend.
Sorry. The Security of Tenure Act, yes.
That's right, the Security of Tenure Act. And, my Lord, in my submission, this is a very short point of construction, which simply arises on the face of the Act, and all of the other material which your Lordships have been pressed with concerning policy and so forth doesn't, in my submission, or shouldn't lead to any different construction of the Act. My Lord, it's an unusual Act because one's often in this tribunal particularly being pressed, or the court's being pressed with the suggestion that a statute is always speaking. This is an odd statute. It spoke only once. It spoke on the date on which it came into force and had effect on that day to convert certain sorts of what are described there as tenancies into these statutory leases, which then endure for 30 years and are then renewable simply by giving notice on the part of the tenant. My Lord, the point of statutory construction is simply this. On the appointed day, what sort of tenancies was it that this Act converted into statutory leases? I mean, in order to answer that question, one doesn't, in my submission, go to Hansard at all. One simply goes to look at what Section 4 of the Act says. My Lord, it's in the orange folder at tab 6. Section 4, subsection 1, notwithstanding any law or agreement to the contrary but subject to this Act, every tenancy to which this Act applies, subsisting immediately before the appointed day, shall, as from the appointed day, become a statutory lease for the purposes of this Act. So one has to ask, well, to what tenancies does this Act apply? That sends the reader back to the definitions section and to the last sentence in the definitions section, section 2. Tenancy shall be construed accordingly, is the last line there. What it's referring to, of course, is what is above.
Isn't the next step section 3.1?
My Lord, yes, your Lordship's right. I'm skipping a step out in the argument. That is right. It applies to tenancies on which, at the time specified, your Lordship has the section there, specified in section 4.1, a chattel house used as a dwelling is erected, or a chattel house intended to be used is in the actual process of being erected. So I accept it doesn't quite cover every tenancy in the whole of the country. But, my Lord, one then has to go, having gone over that step, to section 2, and tenancy is to be construed in accordance with the definition of tenant. And in my submission, what Parliament then lays down is an entirely straightforward and understandable and clear definition of tenant for the purposes of this Act. Any person entitled in possession to land under a contract of tenancy, whether express or implied, and whether the interest of such person was acquired by original agreement or by assignment or operation of law or otherwise, and includes, and I observe, of course, this is an unusual use of the word includes. It's really an extension, in my submission, a tenant at will and a tenant at sufferance. And the short point in my submission is that the nature of whatever it was that Mr. Ramdass Sr. had on the date on which this Act came into force, assuming for the purposes of this submission that my friend is right to say the Rent Restriction Act was in full force and effect, the nature of what he had, which has been loosely described as a statutory tenancy, was, in my submission, not such as to fall within this provision. And, my Lord, one can make that submission good, I say, simply by going to some of the authorities which tell one what it is that the interest of a person under the Rent Restriction Act really consists of. And the first authority in that regard is Keeves and Dean. Your Lordships have already been taken to it. It's the first authority in the slim Respondent's Authorities bundle.
Do we know what was the appointed day for the purposes of this Act?
My Lord, yes, it was the day on which the Act came into force. That's what Section 2 says, and the Act came into force on the 1st of June. Your Lordship has that on the first page of tab 6.
Right, thank you.
Yes, it's the 1st of June 1981, which is the critical date for my friend's submissions. My friend's case rests entirely on the proposition that on that day, the appellant was a statutory tenant, so-called, under the terms of the 1941 Ordinance, the Rent Restriction Act as it became, and that interest was then converted into a statutory lease by this Act. My Lord, Keeves and Dean was one of the earliest cases under the rent restriction legislation, and it's a case directly in point in the sense that it's, as I think Lord Collins has already pointed out by reference to the footnote on the second page, it's a case which was decided by reference to a provision identical in substance and in form to the Rent Restriction Act. And the facts of the case are very simple, and they're set out on the first page of the report. The plaintiff in 1920 let a dwelling house at a weekly, as a weekly tenant to 1 Percy Beach as a weekly tenant at a rent of 12 and 6 a week. No written agreement. Gave notice to quit. Beach didn't quit but remained in possession as a statutory tenant. And I put those in that expression in inverted commas. Under the Protection of the Increase of Rent, etc. Acts, that's to say the 1920 Act on which the Rent Restriction Act in Trinidad was modelled. On the 5th of January 1923, Beach's solicitor wrote to the plaintiff giving him notice that Beach had assigned his interest in the premises by indenture to the defendant Dean. Beach vacated the premises, Dean entered into possession, and the plaintiff brought the action in the Croydon County Court to recover possession of the premises upon the ground that a statutory tenant cannot assign his interest, and the defendant was a trespasser. So the question squarely raised in the case is what is the nature of your interest if you are a statutory tenant under the 1920 Act? And the answer which is given, Lordships have been taken to it I think already, but Mr. Justice Lush in the course of argument says on page 686 nothing more than a status of irremovability. Once the court comes to give its decision, one sees the matter put in a number of different ways, but essentially in my submission they all make the same point. Page 690, Lord Justice Banks, having set out what the question is, says the person who seeks to assign has come to be known as a statutory tenant. And I think it is a pity, says Lord Justice Banks, that the expression was ever introduced. It is really a misnomer, for he is not a tenant at all, although he cannot be turned out of possession so long as he complies with the provisions of the statute. Although he cannot be turned out of possession so long as he complies with the provisions of the statute, he has no estate or interest in the premises, such as a tenant has. His right is a purely personal one, and as such, unless the statute expressly authorises him to pass it on to another person, must cease the moment he parts with the possession or dies. So that, in my submission, very clearly sets out what Lord Justice Banks thought about the nature of the statutory tenancy. I should say in passing that the expression statutory tenancy in England now does have the force of statute. In the more recent Rent Acts, the court's invention of the term statutory tenant to describe this person who, by virtue of the prohibition of possession under the Act, has some sort of interest in the property, has been adopted. The court's description of that as a statutory tenant has been adopted. But at the time that we're talking about in this case in 1923, under the 1920 Act, the notion of statutory tenant is simply a description of the person who, by virtue of the Act, can't be got out as long as he carries on paying what was his rent formerly when he was a tenant. My Lord, your Lordships have looked as well at what Lord Justice Scrutton said, but just by way of brief reference, 694. This case, said Lord Justice Scrutton, is another stage in the unwelcome task which Parliament has imposed upon the courts of defining the position of the statutory tenant. My Lord has objected to his being called by that name on the ground that he is not a tenant at all, but it's a convenient expression. And although it is true that before the passing of these acts no one would have spoken of a person who after the expiry of his tenancy remained in possession against the will of his landlord as a tenant, Parliament has certainly called him a tenant, and he appears to me to have something more than a personal right against his landlord. I take it that he has a right as against all the world to remain in possession until he is turned out by an order of the court, and that he could maintain trespass against any person who entered the premises without his permission. So it's right to say that the description of this right as a purely personal right is qualified to that limited extent, but really only to the extent that what's being suggested is you can maintain trespass against some third party. It doesn't mean that you are properly to be regarded as a tenant. And finally, Mr. Justice Lush, in his judgment on page 697, says, when it is said that a person who perhaps inaccurately is called a statutory tenant, can assign, one necessarily asks oneself what it is he has got to assign. He has no estate in the premises, that has come to an end, and all that the statute has given him is a purely personal right to be free from disturbance by his landlord. It is a very valuable right, but it is personal to him. That's the view that Mr. Justice Lush takes. And the decision of the court, of course, in that case, as your lordships will have perceived, is that one cannot assign whatever it is that is constituted in the notion of being a statutory tenant. My lord, I go to that case principally because, of course, that was very clearly the law in 1923. It must be assumed that Parliament, when it passed the Rent Restriction Act, or the Legislative Council, when it passed the Rent Restriction Ordinance in 1941, understood that that's what was meant by a statutory tenant in this context. And that, in my submission, ought to inform the assessment of what Parliament in 1981 meant when it looked at the definition there of a person who was a tenant within the meaning of the 1981 Act. So the short point, in other words, is does the definition, going back to Section 2 of the 1981 Act, the Land Tenant Security of Tenure Act, does that definition encompass somebody who is not a tenant properly so called, but is a person who may not be put out by his landlord so long as he continues to comply with the covenants under the lease?
There's a very full anthology, as one would expect, of quotations on this subject in McGarry's, the extract from McGarry's Rent Act, tab 33. I don't think there's any need to turn it up, but pages 252 and 253 are stuffed full of similar citations, starting with Keeves.
Well, that's right. Yeah, I suppose I adopt your lordship's observation simply to say this, that it's not as if Keeves and Dean is a sort of one-off and that a different view has prevailed subsequently. It's abundantly clear in my submission that a statutory tenant, whatever it is not a tenant in the true sense of the word, and it certainly isn't, in my submission, a person who is entitled in possession to land under a contract of tenancy. And well, that essentially was the ratio of the two Trinidad authorities that my learned friend seeks either to distinguish or to invite your lordships to disapprove. And in my submission, those cases were rightly decided. And really, in my submission, that is the beginning and the end of what can sensibly be said on that subject. Saved, if I may, just to cover one or two points that my friend made, albeit very briefly. It's not right in my submission to say that Section 3.2 of the Act constitutes an exhaustive list of things that cannot be tenancies within the meaning of this Act. All Section 3.2 does is to set out a list of certain sorts of tenancies which don't fall within the Act. So the submission is really wrong on two grounds. One, it doesn't say that it's an exhaustive list. And two, anyway, it's not dealing with the following species of occupation of property cannot be within this Act. It's dealing with the following types of tenancy. So to say that because the tenancy, in this case, the statutory tenancy, doesn't fall within that list, therefore it must be concluded that the tenancy fell within the terms of the statute, is to beg the question.
You say it's not a tenancy at all.
It's not a tenancy at all. So it doesn't assist. Neither, in my submission, does it assist that in Section 4, Parliament has said, notwithstanding any law or agreement to the contrary, every tenancy to which this Act applies, etc., shall become a statutory lease. That's simply provision that this prevails over any contrary law, but one will need to identify a contrary law to get any submission which made that relevant off the ground, but there isn't any. The fact of the matter is that simply overrides any other law that says something contrary to it. It doesn't assist on the submission that a friend makes. And, my Lord, I also say that it's not right in my submission to say that, I think this was Sir Christopher Rose's point, it's not right to say that Mr. Ramdass Senior's interest had somehow been acquired by operation of law, and that therefore he falls within the definition in section 2. The reference to operation of law, one can see quite clearly from the grammar, is a reference to how the interest of the person under the contract was obtained. But it doesn't follow that if you've got an interest which wasn't obtained under a contract, that you somehow fall nevertheless within the statute. So, my Lord, that essentially is my submission in relation to that. And I do say that reference to Hansard and so forth simply doesn't take the matter any further forward at all. Neither of the two conditions for the admissibility of Hansard is satisfied in this case. This isn't an ambiguous provision. And anyway, even if it was, Hansard doesn't tell you what the answer should be.
I mean, I think he says it's an absurd result. I mean, what do you say on the policy of the...
Well, no, it isn't, my Lord, it's not an absurd result in this sense. This was an act which decided, or Parliament decided by this act, that as at a particular date, subsisting tenancies within this definition, that is to say contractual tenancies, and I'll come on to tenancies at will and tenancies at sufferance, should be converted into something else. But to say that it's absurd to conclude that Parliament didn't also say that another species of interest should be converted into statutory leases, it really has no foundation in my submission. One simply asks, why is it absurd? There's nothing absurd about this at all. My friend said, well, a person who is a landlord under a contractual tenancy could simply serve a notice to quit, perhaps when he read in the paper that this bill was going through Parliament. Well, perhaps he could. But that doesn't make it absurd. If Parliament had intended to catch people who had done that, there would be some express anti-avoidance provision that made the thing retrospective, backdated the date which it caught. That's, as Lordship may have picked up, that's what was done in the Rent Restriction Dwelling Houses Act, which I touched on briefly in my supplementary case. That provided, even though it was passed in 1981, that it should apply to tenancies of dwelling houses subsisting in 1978. So Parliament could have done something like that here, and could have said, even if the tenancy's already come to an end, that law, nevertheless it should be caught by this, but it didn't. And it simply made a decision that said tenancies at this date shall be converted in this way. In my submission, there's nothing absurd about that. It's simply a decision that Parliament took. And of course it creates arbitrary distinctions, but so what? That's what Parliament's entitled to do, unless the distinction is in some way profoundly objectionable on the ground that it infringes some other right. Parliament's perfectly entitled to do that in my submission.
I think you may say that you don't have to, but is there a policy reason for excluding statutory tenants from the ambit of the 1981 Act?
Well, the answer may be, my Lord, that they already have a degree of protection under the Rent Restriction Act. They're entitled, so long as they continue to pay their rent, to remain in possession. The statutory tenancy, so-called, can pass by succession, at any rate once, under the terms of the Rent Restriction Act. There's no obvious reason in those circumstances why these tenants should be given this windfall of a 30-year lease. And it's in one sense, one understands the policy arguments that my friend puts for it, but one might make the point the other way in terms of policy. It's a pretty, in some ways, pretty extraordinary statute, this, that takes subsisting tenancies, which are terminable in accordance with their own terms, and regardless of any provision in them whatsoever, converts them into a 60-year lease. What's more, a 60-year lease in respect of which the tenant then has an option to purchase at half the value. So I mean, it's a fairly draconian statute from a landlord's point of view, but no doubt for that reason that it was regarded by Parliament as being potentially in breach of the fundamental rights in the Constitution. And my Lord, I do respectfully rely upon the point mentioned by Lord Collins in that regard. If your Lordships were of the view, contrary to what I've said, that this were a provision which had some ambiguity about it, or that the construction which my learned friend presses upon your Lordships is a tenable one, I do respectfully rely upon the principle that if one is construing a statute which is unconstitutional, one should try to give it the most constitutional, as it were, interpretation. One should not strain in this statute to make it cover even further categories that it doesn't on its face purport to cover, when the effect, to a large extent, is from a landlord's point of view, is confiscatory. My Lord, it's not, in my submission, a course that ought to be followed. My Lord, so far as my learned friend's alternative argument is concerned on the meaning of the definition of tenant in Section 2, tenancy at sufferance, the short answer to that in my submission is to be found in the case of Remen, which is in the Slim Authorities bundle. Again, it's the next one along. I think it's also in the large bundle. Remon was the case where before the increase of rent, etc. Act came into force, a landlord had terminated a contractual tenancy by serving a notice to quit which had expired. But the tenant, rather than quitting in accordance with the notice to quit, simply stayed there for a few days, and then the Act came into force. And then I think on the very day the Act came into force, the landlord put the tenant out. And the question in that case was whether the Act covered whatever it was that the tenant had, and it was decided that it did by what was accepted by all in the court to be a strained construction. But one argument along the way, which was very firmly rejected, it would appear, is that you could regard a person in those circumstances, that is to say somebody who has not quit in accordance with the notice to quit served upon him, as a tenant at sufferance, and that's dealt with at page 58 in the judgment of Lord Justice Scrutton. About halfway down the page, he says it is true that some of these persons would never previously have been called tenants by any lawyer. And then he says this: the nearest approach to them is tenants by sufferance, who, as Lord Coke says, entereth by a lawful lease and holdeth over by wrong, whose tenure was probably invented to prevent their obtaining a title by adverse possession as decisors. But tenants by sufferance seem to have been confined to persons who held over without the assent or dissent of their landlords, and not to have included persons who held over wrongfully in spite of the active objection of their landlords. My Lord, that in my submission is precisely this case. Lordships will recall on the facts of this case, we have the notice which is served in January 1977, because they didn't manage to get it served before 30th of December 1976. It had to take effect by reference to the additional words, or at the expiration of 6 months, the next period of 6 months after the expiration of this notice. So it took effect on the 30th of June 1978. And thereafter, Mr. Ramdass Sr. was simply holding on in possession. And it's clear in my submission that state of affairs does not constitute a tenancy by sufferance. Mr. Ramdass Sr. could not properly be described as somebody who was in possession with neither the assent nor the dissent of his landlord. His landlord had made the position perfectly clear by serving notice to quit. And if one needs to go any further into that, one can go to the record, my Lord, at page 12, where in the evidence of the plaintiff's first witness, who was Anjani, her elder sister, at the bottom of page 12, she says the rent was last collected when the first notice to quit was served. Thereafter, none was collected. It was a kind of rough relationship. When Bim Ramdass knew that we needed the land, he didn't want to leave, and the family got very abusive. We were still seeking possession of the land. I had asked them to buy the land, and he said he will think about it. I did ask him to give up possession of the land. I asked on my sister's behalf while she was away. Some letters passed. We've asked for copies of those letters, but I'm afraid we haven't got them. But so we don't know exactly what they say. But it doesn't look, in my submission, much like a situation where the appellant is simply indifferent as to whether Mr. Ramdass remains or goes. On the contrary, in my submission, it's on that evidence, which doesn't appear to have been expressly challenged in cross-examination, it was something which was decidedly with the dissent of the appellant or the appellant's predecessors. It's right to say, in fairness, at page 52, that in his own evidence, the appellant says that the relationship remained cordial. But that may be a question of degree. It doesn't assist your lordships really with whether there was this state of neither assent nor dissent which is required in order to make good a tenancy at sufferance.
They cordially disagreed.
My Lord, that's right, yes. My Lord, in my submission, that essentially disposes of the point under the Land Tenant Security of Tenure Act. It wasn't a tenancy, Mr. Ramdass Sr. wasn't a person entitled in possession to land under a contract of tenancy, nor was he a tenant at sufferance. And in those circumstances, he simply fell out with the scope of the statute and can get no protection from it, and nor can the appellant get protection, as it were, derivatively from that. My Lord, of course, that all assumes, and I don't, unless your Lordship want me to, I don't think I propose to say anything further in relation to that aspect of the case. That all assumes, of course, that Mr. Ramdass was a, in quote, statutory tenant at the time that the Land Tenant Security of Tenure Act came into force on the 1st of June 1981. My argument that he wasn't, my Lord, essentially turns on the detail of the provisions which Parliament put through in order to try to reenact the statute. I accept at once this is a highly technical point, and it may be thought to be an unattractive one in some ways, but in my submission, when one looks
None
at
the worse for
terms,
that, you say.
no, I say none the worse for that, my Lord. Because of course it's the foundation of my learned friend's case that he was a statutory tenant under the Act. Well, if one starts with let me just take your Lordships to the right place, if I may. I set it all out at paragraph 11 in my case.
You do accept that the purpose of these various acts was to continue the status of statutory tenants?
I think I'd be in difficulty in saying that there was any other purpose, my Lord, yes. My Lord, it's simply this. If one starts off with the Act as it subsisted in 1980 or thereabouts, this is at tab 2 in the orange folder. The provision at that stage was this Act shall continue in force until the 23rd of February 1981 and may be continued in force for a further period of 3 years at a time by resolution of Parliament.
So where are you reading?
I'm sorry, my Lord, I'm in the orange folder now.
Sorry. Yes.
I'm sorry I keep
My
dotting
fault.
around like this. It's unsatisfactory.
Yeah. Yes.
Tab 2. Tab 2 is taken from the 1980 revision. As your Lordships know, in Trinidad they use the revision method, so every now and then they produce a comprehensive list of their statutes, and this was the one in 1980. This Act will continue in force until the 23rd of February 1981 and may be continued in force for a further period of 3 years at a time by resolution of Parliament. Well, the 23rd of February 1981 came and went, and nothing had been done by way of resolution. So Parliament then turned its attention to the problem with an Act which it passed, which is at tab 4. And in that Act, which was assented to on the 15th of May 1981, having made the provision about the Constitution, Parliament then goes on to say this Act may be cited as the Rent Restriction Act, Reenaction and Validation Act 1981, and this does appear to be the one that my Lord, your Lordship, saw being passed in the Hansard. Section 2, the Rent Restriction Ordinance. It's not quite clear why they call it an ordinance, because it had turned into an act by this point, but anyway, the Rent Restriction Ordinance, hereinafter referred to as the Ordinance, is reenacted with effect from 24th February 1981, and then all things done or purported to be done in exercise of powers conferred under the Ordinance are deemed to have been lawfully and validly done, notwithstanding that the Ordinance ceased to have effect on the 23rd of February 1981. My Lord, the point I make, technical as it is about this, is that, of course, if you simply reenact an Act which says this Act shall lapse on the 23rd of February 1981, then that's what you that's what you do, and it doesn't continue after that. It's not quite such a daft point as one might at first think. At any rate, Parliament didn't think it was, because if one then turns to tab 5, here is Act number 18 of 1985, assented to on the 21st of May 1985, an Act to reenact the Rent Restriction Act, Chapter 5950, the provision about the Constitution. Then at paragraph 2, the Rent Restriction Act, hereinafter referred to as the Act, is reenacted. And at this point, the draftsman appears to have woken up to the problem that the previous attempt to reenact the statute had, save and except subsection 2 of section 1, which is repealed and replaced as follows. This Act shall continue in force until 23rd February 1987 and may be continued in force for further periods of 3 years at a time by resolution of Parliament. And then this provision, section 3, all acts and things done or purported, etc., notwithstanding that the Act ceased to have effect on the 23rd of February 1981. So it appears at that stage that Parliament, implicitly accepted that the effect of the omission from the previous reenacting Act was that the Act, the original Act, ceased to have effect in February 1981. My Lord, that's the short point. I don't contend that it has any attractiveness in terms of the merits of the case, but as a matter of draftsmanship in my submission, that's what the position is. And of course,
and it was recognised to be so by the legislature.
My Lord, yes, that's right. And of course, I make the additional point that the validation provision, validation of acts and things, doesn't help, because the proposition that Mr. Ramdass Senior was a tenant who was entitled to the protection of the Act doesn't depend upon anything done or purported to be done, or acts done or purported to be done under the ordinance. So Lord, that's the short point in relation to that. The next point I make is in relation to the exclusion of premises order. The background to this submission, of course, is this. It's really a further point in my submission for supporting the judge's decision at trial. The Lordships will recall that the issue on the pleadings was really a factual one. Was a notice to quit actually served on the dates that you say it was served, and that the evidence is full of argument about who saw who going where in a car on which day and this sort of thing. The arguments about the law appear to have been raised really for the first time in argument, in closing argument. And the consequence of that, in my submission, is that nobody at trial really explored very closely what it was that needed to be established if the premise of this argument based upon the Rent Restriction Act was ever to get off the ground. One can just pick that up briefly, if I may, in the pleadings, if your Lordships have the record to hand. Page 4, which is part of the statement of claim, contains at paragraph 7 the averment the plaintiff's right to possession is not subject to any statutory restrictions. The defendant's answer to that, I don't know whether your Lordships have page 6A in your Lordship's copy of the record. It was put in rather late in the day. If not, no matter, my Lord, one can, rather than wasting time trying to find it, one can go straight to page 81, which is the draft amended defence that the Court of Appeal was asked for permission to, the appellant asked the Court of Appeal for permission to amend to. But you can see the original text there. At the top of the page, no admission is made of paragraph 6 and 7 of the statement of claim. So there's simply a bare non-admission of the proposition that there is no statutory restriction on the plaintiff's right to possession. My Lord, it's in that context that it's quite clear the bulk of the evidence that was explored at trial was all simply on this question: was it right to say that the notice to quit had been served, or the 2 notices to quit had been served? What I say about that is, of course, that in those circumstances it would in any event have been unfair for the trial judge to have upheld an argument that depended for its success upon the application of the Rent Restriction Act to whatever it was that Mr. Ramdass Senior had once the notice to quit had been served, because the date of the construction of the building, which was not explored in evidence, could have been a crucial factor. I mean, in relation to that, I go back to the orange bundle, and can I just follow it through with your Lordships? The Rent Restriction Act itself, which is at tab 2. Applies by section 3, subject to subsection 2 and to sections 4 and 20, to all land which is building land at the commencement of this Act or becomes building land thereafter, and to all dwelling houses. And in my case, I focused really on the words dwelling houses. In my submission, it doesn't make much difference whether this was a piece of land that was let for the purpose of building on or not, because the fact of the matter is, at the time of the events we're concerned with, there was a dwelling house on it, and Mr. Ramdass Sr. was in the dwelling house. So it applies to all land which is building land at the commencement of this act that becomes building land thereafter, and to all dwelling houses and public or commercial buildings, whether in existence or let at the commencement of this act, or erected or let thereafter, and whether let furnished or unfurnished, etc., being building land, dwelling houses, and public or commercial buildings situated in the areas described in the schedule, and we accept that the property in this case was in an area described in the schedule. There are various exceptions in subsection 2, none of which applies to the present case. And then section 4, the President may, if he thinks fit, by order, subject to affirmative resolution of Parliament, subsection 1, little d, exclude from the operation of this Act any specified premises or any specified classes or descriptions of premises, or any specified classes or descriptions of premises in a specified area. Well, that's the power that's being exercised when the President makes the rent restriction exclusion of premises order, which is at tab 3. Paragraph 2 of the order, the classes of premises described in the schedule are excluded from the operation of the Act as from the date specified in the schedule. Schedule Part 1, and as Lord Walker points out, there's no main verb because this is simply a description of a class of premises. As from the 12th of February 1954, all new buildings, the erection of which was completed on or after that date, together with any land appurtenant thereto and to be occupied therewith. My Lord, I respectfully submit that there's no great magic in that, and there's no distinction there between building land and dwelling houses and so forth. This simply applies to exclude from the ambit of the Act what it says it covers, all new buildings, the erection of which was completed on or after 12th of February 1954, together with any land appurtenant thereto and to be occupied therewith. And there's no magic in paragraph 2b of Part 1 of the schedule. The erection of a new building shall be deemed to have been completed on the date on which the first tenant or occupier enters into possession of the said building. That's simply to avoid ambiguity as to the date on which a building is completed. No doubt the draftsman had in mind the fact that lawyers are capable of a lot of argument about the date of completion of a building. It means different things to different people. So there's no magic in that in my submission, and it has this consequence, that if, in the present case, the dwelling house on the land subject of this appeal was a dwelling house which was completed on or after the 12th of February 1954, then it was within Part 1, Paragraph 1 of the schedule to this exclusion order, and it was therefore not within the ambit of the Rent Restriction Act at all. And so the whole argument upon which my learned friend's case turns falls away, because there's nothing to convert into the statutory lease under the terms of the Land Security Act.
And do you make any point about the later parts of the schedule, in
Well,
part 5, for instance?
I have to confess, I was looking hopefully to see what your Lordship had in mind for my case.
Well, what about part 5?
Part 5.
Does the owner mean the tenant who has built the house?
All dwelling houses on which, on that date, was in actual occupation of the owner. Yes, I suppose it depends on what, it does depend on what one means by owner, doesn't it? I must say, I'd read that as meaning owner in the sense of landlord, freeholder. But it may be that's not right.
A landlord doesn't need protection for his own house, does he?
My Lord, I suppose that's right.
It's an odd use of owner, but
yes.
it fits in with the notion of the chattel house belonging to the tenant, doesn't it? I suppose.
My Lord, I suppose that's right, yes. In which case, certainly if that applies, that would be a bull point in my favour, because on any view of the evidence, Mr. Ramdass Sr.
I mean, you may say that you don't need this point, but if we are faced with the fact that the Attorney General in the Hansard we've seen made no reference to this problem, and that the judge at first instance, and you say, well, it wasn't pleaded, but we know that judges at first instance dealing with possession cases of this sort, he must have known very, very well how the Rent Restriction Act worked, and he doesn't seem to raise the point. So I ask myself just how how important were the Rent Restriction Acts when this case was heard?
Yes. Well, no, as I say, it doesn't appear to have been raised except as an argument at the end of the hearing. And I mean, in answer to the question, how important were they? I mean, they were plainly important to the submission that the appellant was making at trial, because the whole thing depends upon being able to show that Mr. Ramdass Sr. was a statutory tenant within the terms of the Rent Restriction Act.
Yes.
But my lord, I don't know precisely what. I don't have I have to confess, I don't have a clear position on exactly what paragraph 9 means. But what one can certainly see, the effect of this order is, which obviously, as one can see from the side notes, has gradually been amended over the years. Fresh orders coming through to add new categories of thing that don't constitute premises within the scope of the Act. The scheme is plainly to take away gradually protection.
Oh, this order has been added to over the years, has it?
Well, I think that must be right from one looks at the side notes.
Yes, I see.
Because the way but this copy is taken from the 1980 revision of the Act. So the side notes tell one which bit of legislation it is that's gone into producing the result that you ultimately see.
So it's sort of creeping barrage of lifting of statutory protection.
Well, that's essentially right. And I have to be frank, I had read, and I looked at all these paragraphs hoping to see what else I could find that might assist the respondent. I had read paragraph 9 as being dwelling houses which were in occupation of the owner in the sense of the freeholder. And
That wouldn't make sense, would it?
Well, it might in the sense that if you're in occupation of, if you live in your house in 1967 and thereafter you let it to somebody, that is not a property which then attracts the protection of the Rent Act. But the Rent Restriction Act does apply to tenancies which were granted at an earlier stage. So it's not necessarily completely absurd. I mean, as your Lordship I'm sure knows, in England the position is much more straightforward. There's a date in 1989. Anything created before that is a Rent Act tenancy and stays one, and anything created thereafter has to be a Housing Act tenancy, and is subject to an entirely different regime. But that's probably about as far as I can take that, my lord. But I take the point entirely that the trial judge might reasonably be expected to be quite familiar with the terms of the rent restriction legislation. Certainly the English cases are replete with references to the county court judges being experienced at dealing with this sort of thing, and in practice of course it's right that judges often take these points even if the parties haven't thought of them. But in this case, where the express averment is made that there is no statutory protection and nothing is said in answer to that other than a non-admission, it would, in my submission, be jolly unfair if the appellant were now able to rely upon the Rent Restriction Act, there not having been any exploration at trial of the issue as to when the property was actually built. Because if one turns to, if I might just take the Lordship's briefly to the facts, I've set them out at page 7 in my case, paragraph 23. What we appear to know from the record is simply that in 1960 the defendant was born. He grew up at the property, so it must have existed in 1960. But that at some date before that, his father, Mr. Ramdass Sr., had built a house at the property. My Lord, unless my memory fails me, I don't recall anything else in the record which assists on the question as to when the property was actually built. I mean, I quite accept it's perfectly possible that it had been there for years and years and years before 1954, in which case it would not seem to fall within the terms of the Rent Restriction Exclusion of Premises Order, but one simply doesn't know. And I say that it would have been unfair for the judge to find in favour of the appellant on this issue, that the issue of the date of the property's construction not having been explored at all at trial. Well, that's really all I want to say on that aspect of the matter. The next matter I want to touch on briefly, and I haven't very much more to say, is, and it's in a sense a new point coming from this side of the court. It's the question of compensation that the trial judge ordered the appellant to pay. I only, the respondent to pay. I only say it really to make this observation that there doesn't appear to be any statutory basis for that payment to have been ordered. And I accept that the order was made, hasn't been the subject of an appeal, either to the Court of Appeal or before your Lordships. And it may be I'd be pushing my luck rather to ask for leave to appeal now. I think
you might push it pretty hard.
I won't, my Lord, I won't press it. But it is a curiosity, which, I mean, your Lordships may, I don't know what your Lordships want to make of it either way, but one can certainly find specific provisions. May I just, out of interest, take your Lordship to two of them very briefly, which do provide for the payment of compensation.
Is this going to help us, Mr.
Well, my Lord, it depends what your Lordship want.
I mean, you're not appealing on it. You haven't appealed this.
We haven't appealed, my Lord. No. I mean, can I just say for your Lordship's note, so that in case your Lordships want to say anything about this aspect of the matter in your Lordship's judgment.
I think it's unlikely. We haven't really. It hasn't been explored, Mr.
Well, my Lord, so be it. There are two provisions in statute which allow this.
In statute.
Which will allow, in certain circumstances, one is where you terminate a Rent Restriction Act tenancy on one of the approved grounds, non-payment of rent, etc.
Just give us the reference.
Yes, it's section 14F, sorry, 14(5), forgive me, of the Rent Restriction Act. And it's section 5(4)A of the Land Tenants Act. 5(4)A. That's of the Land Tenants Security of Tenure Act. It's actually the Land Commission which you have to apply to in those circumstances, which makes the order. So it may be that as my learned friend knows much more about this in practice than I do, being a member of the Bar of Trinidad and Tobago, as I am not, but it may be that it's simply a practice that's grown up, but there it is. I take your Lordship's indication that any further pressing on this will not be received warmly, so I won't do it. My Lord, that, I think, leaves simply the question of, I'm not sure whether my friend pressed the submission which was made, certainly in the printed case, that one should simply regard the appellant as a tenant by succession under the terms of the Rent Restriction Act. The short answer to that is that the Act was not in force at the time of the trial, and the duty of the trial judge was to apply the terms of the legislation as it applied as at the date of trial. This is the new point which was not taken before the trial judge. The point before the trial judge, as your Lordships will have seen, was the point under the Land Tenants Security of Tenure Act. I am the assignee, or rather the devisee under the will, of my father's land tenant security of tenure statutory lease, which he had by virtue of having been a statutory tenant under the Rent Restriction Act when he died, or indeed, rather, when the appointed day arose. I have to get one's dates right in this context. As I understood it, a further point that's made in the printed case is to say, well, even in his own right, the appellant was a tenant by succession under the Rent Restriction Act. That's to say, simply by virtue of his status as a member of the household, as it were, of the family. The short answer to that submission, as I say, my Lord, is that the Act wasn't in force at the time of the trial. So, whatever complaint might be made about the delay that it took to get the matter to trial, the duty of the trial judge was plainly to apply the law as it then stood. And the Rent Restriction Act, if it would have assisted the appellant, which in itself may be a question, but it wasn't in force in any event, as at the date of trial. So one simply can't, in those circumstances, rely upon it as giving the appellant a direct right to say, I am the successor under the terms of the Rent Restriction Act. Even if your lordships were minded to follow that route, the alternative argument I would put in relation to that is really another one based upon the pleadings. It's that if one is going to have an argument about whether somebody is a successor under the terms of the rent restriction legislation, it needs to be fairly flagged up so that the relevant issues can be explored. Because the entitlement to claim as a successor, can I just take your lordship to it very briefly so I'm not making submissions completely in the abstract? It's in section, if it goes back to tab 2, or wherever else conveniently your lordships have the Rent Restriction Act. It's page 5 at tab 2, my copy, section 2. Under the definition of tenant, toward the end of the definition section. Tenant includes subtenant, which we didn't worry about, B, the widow of a tenant who was residing with him at the time of his death, or where a tenant leaves no widow or is a woman, such member of the tenant's family as was residing with the tenant for not less than 6 months immediately before the, etc., etc. My lord, as I say, the point I make is that's what I mean by the tenancy by succession. That couldn't be relied upon by the appellant because this provision wasn't in force at the time. The only way in which this provision could have been relevant would have been by virtue of saying to the judge, don't make an order for possession against me, because I'm a tenant within the terms of this Act, or rather I'm a person in occupation and defined as a tenant under the purposes of this Act, and therefore I am protected by section 14, which says that you're not allowed to make an order for possession of the land. 14, no order or judgment for the recovery or possession of any premises to which this Act applies shall be made unless, and there's a whole series of specific grounds for possession, the cases as they're known in the...
Did you say that if he would have been entitled, if he could have had such an order when the action was raised, did you say that nonetheless he ceases to be able to have it? Is that right?
Well, that's right, yes. I say there's no basis upon which the judge would have been entitled to say, notwithstanding the fact that this Act, which by its express terms only takes effect for a limited period and then stops having effect, has lapsed. Nevertheless, I'm entitled somehow to apply it all the same. I mean, in my submission, it doesn't work. The only reason upon which the judge, the reasoning that the judge would have been following, had he said, I refuse to grant an order for possession because I regard you as a person within the definition of tenant in the definition section of the Rent Restriction Act, the reasoning would have been, I cannot make such an order because section 14 of the Act precludes me from doing so. But section 14, of course, didn't preclude him from doing so because section 14 didn't exist at that time. The whole of this Act having simply been allowed to lapse under its express terms. Well, it, as it were, cuts both ways in this jurisdiction. If I take your lordships, if I may, briefly to, I think it's the case of, one moment, I'll give, I think it's the case of Jauncey, which is in the orange folder, I think. No, it's tab 9 in the orange folder. As I can just take your lordship to the head note. In October 1945, the tenant of a house within the protection of the Rent Restriction Act sublet 2 rooms in it, sharing the use of the scullery for cooking with the subtenant. The subtenant subsequently bought the house subject to the tenancy, and in his capacity as landlord served a valid notice to quit on the tenant expiring on the 25th of April 1949, and on the tenant's refusing to comply with it on the 25th of May issued a plaint claiming possession. On that date, as the law then stood, the tenancy was not within the protection of the Rent Restriction Acts, owing to the sharing of the use of the scullery. On the 2nd of June 1949, the Landlord and Tenant Rent Control Act 1949 came into force, by which sections 7, 8 and 9 extended the protection of the Rent Restriction Acts to the various cases where the tenant shared accommodation with others. And by section 10, those 3 sections shall apply whether the letting in question began before or after the commencement of this Act, but not so as to affect rent in respect of any period before the commencement thereof, or anything done or omitted to be done during any such period. And the county court judge held that law applicable was the law applicable at the date of the issue of the plaint and made an order for possession. And on appeal by the tenant, those cases were distinguishable upon which the judge had relied, been misapplied. They only established that in considering whether there was a letting within the Rent Restriction Act, the law must be applied to the state of facts existing at the date of the issue of the plaint, and had no bearing on the question whether the law applicable was the law as it existed at the date of the issue of the plaint or as it existed at the date of the hearing. But on the true construction of Section 10, the relevant provision applied to pending actions. And then there's reference to a statement by Lord Jessel. Accordingly, the law applicable was the law as existed at the date of the hearing, and as the tenancy was then protected by the protection of the Rent Restriction Acts by virtue of the Act of 1949, there was no jurisdiction to make an order for possession. My Lord, it's not a directly in point, it's the other way around, but the point, of course, is simply that in that case, rightly in my submission, the Court of Appeal said, well, you apply the law as at the date the judge is actually being asked to make the order for possession. And here, the law, as at the date the judge was asked to make the order for possession, provided for no basis upon which an order for possession could not be made. So the common law essentially was back in force. And that's, of course, the premise of my own friend's edifice that he seeks to build based upon the Land Tenant Security of Tenure Act.
I have a sort of recollection that whether or not statutes apply to existing proceedings partly depends on whether you classify the thing as relating to procedure or not. If it relates to procedure, then there's a sort of presumption that it does apply, but otherwise a sort of presumption that it maybe not presumption that it doesn't. I mean, I don't.
Yes, well, I think that's right. With respect, the point in relation to this case is that we're not talking, I say, about a procedural matter at all. We're talking about the right of the landlord to possession. Yeah. And the only thing that stands in the way of that right is the Act.
And it comes,
the Act, by its express terms, is limited in time. And if one thinks there's no injustice in that, in fact, because, of course, if the court had got on with it and listed the thing for hearing 6 weeks after the pleadings had closed, then it may be that if they thought of it, they could have taken this point. But of course, as soon as the Act lapsed, the court could have made the appellant could have issued another claim to which there would have been no defence. So it doesn't. It couldn't be right in my submission for your lordship now to say effectively no. That there is a subsisting defence to this Act based upon the fact that some years ago there would have been such a subsisting defence. So, my Lord, that's all I want to say about that. I don't address your lordships on the Act which I discovered in the course of my reading yesterday and which troubled me but doesn't trouble my friends. So I'm perfectly content to accept his concession that doesn't apply. That only leaves the question of the mean profits, and that can be put fairly shortly. If I am right that the Rent Restriction Act, by virtue of Parliament's slip, was not in force at all in the period between 1981 and 1984, then I think it follows that I have to get this right around. I think it follows that from the date of the lapse of the Act, both the appellant and his father were in occupation of the land as trespassers, and therefore they're both liable to pay mean profits. If I'm wrong about that, and the appellant's father was a statutory tenant, albeit that wasn't obviously converted into anything else, then it follows that my friend is right, and that mean profits were wrongly awarded from a date before the late father's death. And my friend's quite right to say, if you look at the pleadings, since I've made lots of points about the pleadings, it's only fair to say that our pleaded case was that we should have mean profits from, I think there was a typo in the statement of claim, but it was obviously intended to be, as my friend rightly says, from the day after the death of the late Mr. Ramdass, because it was from that date that on the judge's findings the defendant went into possession. But I think I omitted to say simply this, my Lord, just one final point in relation to the Rent Restriction Act and the question of succession. under section, under the definition section in section 2. Of course, that in itself raises an issue of fact, which wasn't fairly flagged up at trial, which is to say whether, in fact, he was a member of the family residing with the tenant for not less than 6 months before the date of the death of the tenant. It seems to have been perhaps assumed in my friend's submissions that he was, because he was born there and he was living there at the time of the trial, but I mean, he was 24 at the time of his father's death. We know he had a job a few years earlier, 8 houses away, but there was no evidence, and it wasn't explored at trial, where he was in the 6 months, which is the critical period for establishing that you are a tenant by succession, even if you're allowed to do that. So I say, even on that basis, it would have been wrong to have entertained that at trial. My Lord, those are my submissions.
Thank you very much indeed, Mr. Rowe. Mr. Hyam.
Just dealing with the observation my Lord Roger made in relation to the status of a statutory tenancy, whether in fact it's a true tenancy at all. There has been some development of the law as to the status of these types of tenancy. If I could ask your Lordships to simply look at tab 1 in my bundle and the margin note on page 21. It's the Rent Restriction Act, my Lord. Page 21, the margin note, conditions of statutory tenancy, next to section 15. Now, my Lord, I accept that when the Rent Restriction Acts were being adjudicated upon in the 1920s and so on, a margin note was not necessarily considered part of the Act. That has now changed following the decision of the Crown versus Montilla from the House of Lords. And I've put that decision in your Lordship's bundle. Can I take your Lordships to it now?
I think we're familiar with that.
Very well. I simply point out, my Lord, that because it is recognised as part of the statute and it is a statutory tenancy, it's sufficiently firm to be caught by section 3.2, which excludes various tenancies, and a statutory tenancy is not listed. My Lord, the second point, where my learned friend has said that it's not clear on the evidence that no demand for land was made. Can I ask your Lordships to look at page 13 of the record again? Because my learned friend missed out.
13, was it?
Page 13 of the record, my Lord. This is my learned friend dealing with the point that Bim Ramdass was a tenant at Sufferance. I've made the point that following the transfer of the land to the respondent, she made no assent or dissent to Bim Ramdass remaining on the land. Looking at the top part which my learned friend read, we needed the land, he didn't want to leave, and the family got very abusive. We were still seeking possession of the land. I had asked them to buy the land, and he said he will think about it. And then she explains who she spoke to. That was Herman Ramdass in 1994. At the end of the 30th of June, I did ask him to give up possession of the land. I asked on my sister's behalf while she was away. So, my Lord, that confirms as a matter of fact that no demand was made to Bim Ramdass between the 7th of January and the 1st of June 1981, and that would bring him within the definition of tenant at sufferance. This demand was made from the appellant in 94. My Lord, in dealing with my learned friend's submission that the Rent Act did not apply, if he's right, then on the definition offered by Hill and Redmond as to what a tenant at sufferance is, then he is not there by way of statutory right under the Rent Act. And again, on the facts I've drawn your Lordship's attention to, he would then even qualify as a tenant at sufferance because the Act was not enforced at the time. My Lord, finally, the submission in relation to the exclusion of premises order. Can I just ask your Lordships to look at page 66 of the record? This is the judgment of the High Court judge, who, as my Lord Roger has observed, would probably have been quite familiar with the legislation, the Rent Act legislation. And it's page 66, the middle paragraph. And this is the finding of the judge, notwithstanding the fact that the tenancy was duly determined by the notice to quit served during the first week of January 1978, the tenant, this is Bim Ramdass, nevertheless continued in occupation of the said land as a statutory tenant in accordance with the provisions of the Rent Restriction Act. So at this part, the High Court judgment, which insofar as he found facts we accept, Bim Ramdass was a statutory tenant. And it supports what I said earlier, that the exclusion of premises order did not apply to what is building land as opposed to the dwelling house. My Lord, the final point my learned friend raised was in relation to pleadings and the fact that a pleading should raise the Rent Restriction Act if it is to be relied upon. That has actually been put to rest some time ago in the decision, if your lordships bear with me, in the decision of Smith versus Poulter, which is at your lordship's page 20. I draw your lordship's attention to this because if the Rent Act applied to Bim Ramdass and therefore the appellant by succession, that is a matter of statutory definition. I adopt what is in my printed case that deals with that. But if your lordships look at page 341 of the case of Smith and Poulter at tab 20, page 341, your lordships look at the very top of Mr. Justice Denning's judgment. He makes absolutely clear that the provision limits the jurisdiction of the court to order possession, with the result that in any case where there is reason to think that the house is within those acts, and this is the important part, it is the duty of the court to see whether the conditions required by the acts are satisfied, even though no such point is pleaded or raised by the tenant. And that is why, my lord, I did not pursue before your lordships the application to amend the pleadings. It would have made no difference. The court is obliged to apply it, if indeed it was the law that they could apply. My lords, finally on this point, can I take you to tab 42? And this is a mandatory consideration of the Act, page 23/68 of Woodfall. And the short point is, in determining any claim for possession of premises subject to a regulated tenancy, the court must have regard to the limitation on the landlord's rights imposed by Section 98 of the 77 Act. The rule applies even though the Act has not been relied on by the tenant as providing a defence, and even though the point is not raised by the parties at all. A defence based on the security of tenure afforded by the Act may be taken in the Court of Appeal, though not raised in the County Court. So, my lord, it puts to rest in my submission that if it's not pleaded, it matters not. It is a matter your lordships can deal with on the evidence as it stands. My lord, those are my submissions. Can I assist you further on any matters that I've raised?
No, thank you very much indeed.
Grateful, my lord.
I want to say before I sat down that if your lordships were in my favour, I can't ask for regret for my costs, but certain fees and disbursements have been incurred, and I'd seek an order for those.
Very well. We're very grateful indeed to both counsel and those instructing them, and especially for doing the work late on in the day when just instructed. The board will take time to consider their judgment.